Well, I think it is time to open our 34th Global Digital Encounter on a thrilling and fascinating topic, AI, artificial intelligence, copyright, and licensing. Well, we choose this topic because this is a topic of extreme relevance in the current days, in the current months for our future, as AI is profoundly changing the rules of the game for copyright and also for copyright licensing that relates, of course, to it. At the same time, copyright as well reshaped and will continue to shape licensing. The norm-setting approaches taken up to now by the US, by the European Union and its member states, by China and other countries in Eastern Asia, these norms are not converging. Will they converge? How will copyright live with artificial intelligence and artificial intelligence will live with copyright? Will synergies be useful to stakeholders, to business circles, to users, so that there is a framework that is a global one that is of good quality? This is something that depends on lawmakers, on jurisdictions, on law enforcing, and this is, of course, something of key interest to the whole Global Digital Encounters family. We are happy to have with us connected today professionals from all over the world, academics from all over the planet, and also senior students from all over the world as well. We thank very much those who permit this pro bono activity. As Fide and as Transatlantic IP Academy, we are extremely proud that we are already at the 34th Global Digital Encounter. And we thank above all our extraordinary speakers who tonight for those who are on other continents, or this morning for those who are in the Americas, who will explain, detail, present what are the challenges. So we have esteemed speakers from Europe this time. Why from Europe? Because Europe has just passed the Artificial Intelligence Act, so having very much in advance legislation. Europe watches the world and the world watches Europe. And this is why we have asked our distinguished speakers, Avvocato Marina Lanfranconi, who is the principal of KPMG Italy, Valentina Moscon from Max Planck in Munich, and of course, as moderator, Professor Javier Fernandez Laschetti from IE University and El Saburo, to be with us today, precisely to enlighten us, to open a debate on which, at the Global Digital Encounters, we will continue to work together, not in our ivory tower, but with all of you, dear audience. I declare the 34th encounter open and warmly greet our speakers and moderator. Thank you.
Thank you. Thank you very much, Laurent, for the introduction to the topic. You had a broad explanation of how the AI is affecting the copyright, the intellectual property in general. And yes, you're totally right. And there are so many topics to discuss about this. Unfortunately, we only have some 55 minutes, 60 minutes at all. And we will try to focus on certain issues. And this could be the first of a series of discussions about this topic. So thank you, Valentina and Marina, for being with us. I'm very comfortable being with you because you are very brilliant speakers. So my role as moderator will be very limited, and I can enjoy your thoughts and feelings about this topic. Let's start from the beginning. I mean, we have been discussing for a long time, years, about how the AI will impact or is impacting the copyright, the intellectual property in general, but the copyright in particular. But let's talk about about it in a different view. I mean, why copyright has an impact on AI? Does copyright has an impact on AI, and which is the impact of copyright in AI? Valentina, for instance.
Thank you. Can you hear me?
Perfectly.
Perfectly. Okay, thanks. First of all, I want to thank you for the invitation. It's a pleasure for me to be here in this encounter. And I think it is a very nice opportunity to give some idea, but also to learn from you and from the audience. So yes, I have to start, and as mentioned from Javier, I will start with a short introduction about from the technical point of view. Maybe it's well known, but it's always useful to go back and understand exactly why we are talking about the impact of copyright on AI. It should be mentioned then that the training of artificial intelligence models, including generative AI models, require a very large amounts of quality data. And when I say quality data, I mean also data that are compliant with law. And the first usable source today is obviously the web. AI models developers typically indeed use web robots to collect tests, pictures, and other content by automatic website scraping. Also, if data of a certain quality is desired, it's possible to turn to selected contents, such as databases of text, news text, for instance. This reminds the New York Times, pending litigation, or images, so the getting images litigation, music, etc., or any type of content that may be included in a database. Also, computer code could be ingested by AI systems in connection with the development of AI models. Artificial intelligence has made a remarkable step lately in natural language processing, machine learning, and pattern recognition, making it possible for machine even to understand and teach coding languages. But much of this content, the content used for AI training purposes, is covered by copyright and copyright-related rights. That's why we are speaking about copyright and AI. I would leave the floor to Marina to add maybe something on this matter, if she wants.
Yes, thank you,
please,
Valentina.
Marina.
Thank you. It's a pleasure to be here, and I will go immediately into the subject. So, in fact, the question to be addressed is not exactly a new one. So, namely, the question on how reward can be brought to creators, authors, or copyright holders globally for the creations of their let's say, original works, granting them an exclusive right to control how their works are made available to the public. It can be needs now to be dealt, including the availability of these works in complex technologies. So it needs to be dealt in another perspective. But already in the TRIPS agreement, if you think about it, it is acknowledged that the exceptions to copyright owners' exclusive rights need to be descripted only and only upon certain special cases which do not conflict with the normal exploitation of the work and do not unreasonably prejudice the so-called legitimate interest of the right holders. And so these are exceptions which in US systems are called fair use or causes of justification. So whether they're incorporated in common case law or in civil law statutory systems, the issue is always the same. So of course these laws came into arise before artificial intelligence technologies, and so now we have to the issue to be raised is really where is the line between copyright and permitted acts can be drawn. and IE is currently, and this issue is currently being determined by the different legal systems, and at the moment it appears in slightly different ways. So I deem that on this subject, international cooperation will really play a relevant role in the interplay between IE systems, artificial intelligence systems, and copyright. But just to remind you, recently the European IE Act has been approved. Of course, it has different terms of coming into force, but the recommendation exactly deal at the start of the recommendation, recommendation number 105, exactly deals with this aspect. So why copyright should have an impact on artificial intelligence. And what we can read from this recommendation is that general purpose models, I mean, most general purpose models, including large generative models, are in fact capable of generating all these text, images, and other content. And here there are unique innovation opportunities, but also all this can really challenge artists, authors, and other creators and the way they create content and the content is distributed. So if you read the recommendations, which is really the main part of the IE Act concerning intellectual property, unfortunately, it says that the development of training of such models require access to vast amounts of text, images, and videos, as we were saying, and also other data. And yes, text and data mining techniques can be used extensively, and then we will speak also about these aspects. But in the end, it all recalls to the fact that any use of the copyrighted protected material and the contents as a general rule that does require the authorization of the right holders concerned. And this is unless the relevant exceptions and limitations apply. So this is really the general rule recalled also in the IE Act.
Yeah, so but Marina, from my point of view, the AI regulation, I mean the AI Act, was not driven at the very beginning to deal with that type of issues, but more on a risk approach and AI models that can harm the people and so on and so forth, and can be against our principles, our ideas and thoughts about how the society should be. And then we got surprised because of the invasion of LLMs and other types of artificial intelligence that were quite different to the ones the regulation was concerned about. So that it was I wouldn't say a last minute regulation, but it's still open, don't you think so? Because I mean the references to copyright or to issues that are related to the use of LLMs with regards to intellectual property rights, and specifically on copyright, are so it's a very low level of determination, so that it may be possible that in the future there could be some complementary rules. Don't you think so?
Yeah. I really agree. I totally agree. And to that end, also a recommendation providing for providers general purpose of IE models that should put into place a policy to comply with the Union law on copyright and related rights. It's a really general provision, and it leads exactly to the point you were making.
Yeah. I see. Yeah.
And national law are trying to compensate, but this there are some attempts. Some of them are quite unfortunate ones as well too.
Yeah, well, we'll see what happens in the near future. The Commission is still going into this issue on how to improve the AI regulation with regards to the questions of copyright and in general IP rights. And what's another issue that you have both mentioned, that is the how important are the copyrighted materials with regards to the use or the training of AI. I mean, apart from the fact that there's a vast amount of data that is used for training of AI, not only copyrighted materials. And there's another issue, that is the use of synthetic data that is now going into the issue. What's your opinion about the importance of or the relevance of cooperated materials in the training of AI machines. Is it so relevant? I mean, it's less relevant than we believe.
Yes. May I?
Yeah, sure.
Yes. I think that in this respect, as your question is very relevant, because I think that first of all, we have to mention 2 points. The first point is the threshold of originality required for copyright protection is very low. That means that a lot of content, we don't believe how much content is covered by copyright. Almost everything that we have on the web is copyright protected. Also, and this is my second remark, that many digital content that is not protected by copyright is nevertheless protected by copyright-related rights. Let's think about sound recordings, video recordings, but also if we think at the European level, we have a relatively new press publisher neighboring rights, so pre-published copyright-related rights, which overlaps with the copyright on the news. Also, in some member states, we have, I would say, special copyright-related rights, like those on non-creative photos. This is the case of Italy, for instance, or even Germany. And we have a lot of pictures, a lot of images, a lot of photos online, which then enjoy copyright-related protection. So I would say the copyright landscape, so the landscape of copyrights and copyright-related rights that play over the content used for the training of AI system is absolutely varied and complex. If one thing that copyright and copyright-related rights have different duration of protection, and those rights may even belong to different right holders. As mentioned, the press publisher related right expires 2 years after the press publication is published, while the copyright on newspaper article qualifying as works obviously expires 70 years after the date of the author. So we really have a huge amount of copyright protected material and a complex, I would say, legal landscape that makes the situation even more difficult to deal with for AI developer.
Mm-hmm. Mm-hmm. Yeah, well, there are several discussions about it. One is whether or not some materials are cooperatable, and the never-ending discussion about the difference between the mere photography versus the artistic photography. It seems to me that there's no discussion. I mean, there are no legal discussions for the or considerations for the platforms that want to use that type of materials, because what they want is a vast number of materials to be used in the training. That's why the very recent debate or discussion or concern about the use of photographies posted by the people in Instagram, and it's possible restrictions of use. So there could be always room to that type of discussions, but
absolutely.
Yeah, go on. Yeah.
Yes, absolutely, I agree with you. I mean, then this will bring we will maybe go back to this when we will talk about the licensing challenges. But this I would say fragmented situation when we look at the right that we the AI developers should license, it's immense, and so this is already an anticipation of the challenges of voluntary licensing. But I don't want now to speak about that. Maybe we'll go back later on that. But yes, definitely we have.
Yeah, there's another issue as well, that is or the defense that some of that platforms are using on the question of whether or not the machines are copying or are reading. You know, But that's another story. I mean, you read and understand and take some considerations, and you can rephrase something or paint something like the thing that you were watching or reading. Is the machine doing the same thing, or is it a different one? Well, but that's a very difficult question. Unfortunately, this is in the hands of the courts of justice. So we don't need to give an opinion. That just sit and wait until the decisions are coming from the US. Well, there's a different system than in Europe, with the question of the fair use, etc., etc. But let's see what happens. Okay, let's see what happens.
Yes.
But there's another question that we have missed, maybe Marina, about the question of prompting, the value of prompting.
Yes. Well, going back to what you were saying, also it would be like reading and inspiring yourself and then changing. But in the end, if I even memorize a poem or a song while I'm walking on the street, that doesn't mean that then I can have an outcome which is identical to that poem or a song and exploited externally. So this, I think, is also an interesting point, even if there is not a mere reproduction, or there could not be a mere reproduction, but still there is a use of a known copyrighted content, if of course there is a copyrighted content. So I agree with what Valentina was saying on the prompting. I mean, there is a great debate, but skillful prompting is of course very valuable. So it could be important to content of prompts for its own purposes, and this may include, for example, refinement of the AI systems. Also, I think that copyright laws traditionally provide protection for creative results which are achieved by human beings, and so consequently human-made works, or at least made works made by human contribution, could enjoy copyright protections. And so you really should carefully evaluate if the exploitation of large volumes of data used in the prompting of the machine, of the learning of the machine in the prompting phase, which are product of other IP rights. So here we're in the phase of the input of the prompting, are the result of economic investments, and the right holder has not expressly opted out from this option. I think Valentina was underlining this exception. So if you want to, Valentina, make reference to this. No, you are in mute, because we were discussing with Valentina this aspect.
Thank you. Yeah. Yes, thank you, Marina. Sure. I mean, first, I agree with also Javier mentions the fact that it has been debated whether what is used to train the AI model is really the author's expression, or is rather mere ideas and information which are not protectable. However, technically, the training of AI models involves reproductions, and this copyright material, this reproduction of copyright material, although functional, so to say, to extract ideas and information, are in principle, as Marina already highlighted, subject to prior authorization by the respective copyright holders, unless this reproduction is permissible under copyright permitted uses. And here, I would say that as far as the input aspect is concerned, there are two main approaches. The first one is to frame the uses of the training of AI models in the traditional categories of copyright by leveraging the flexibility of copyright. For example, the US fair use system may allow the use of works for the purpose of the AI training to be considered lawful, and this is what we are waiting for this pending litigation to clarify. And the second approach is the one undertaken by certain countries and also by Europe, and it is to introduce ad hoc rules to regulate the matter. This is the case, for instance, of Japan, that, as we all know, introduced a very broad text and data mining exception, and the case of Europe that introduced under Article 3 and 4 of the Copyright Directive in the Digital Single Market of 2019 two exception. One specific, a very narrow section for scientific purposes, and one broader, or I would say general exception of text and data mining that is not limited to scientific research, but it has a carve out, and this means that allows for an opt-out mechanism. So the exception applies only on condition that the use of works and other subject matter has not been expressly reserved by right holder in appropriate manner, such as machine readable means in the case of content made available online. And this is also an issue that has been discussed and is under discussion nowadays. And it has been argued that this provision, the text and data mining provision, are not applicable in the context of AI, because the EU legislator did not consider at the time this type of data analysis. But the recently adopted AI Act that has been already introduced rejects, I would say, this view, confirming on the contrary the applicability of the provision of text and data mining to AI development. So what we have now is a situation where the European legislative architecture, I would say, gives to the right holders the opportunity to exercise the exclusive rights, meaning also exclusive control over the use of their works for AI training purpose. And this is a very challenging issue, because first of all, it's very difficult to set the meaning of appropriate opt-out, and secondly, once the opt-out is exercised, what happens? I mean, what is the next, so to say?
Mm-hmm. Yeah, it's a difficult issue, of course. Marina, would you like to add something? We talked about inputs. We haven't talked about output. That is also an issue.
Yes, and going back to input, I think Valentina addressed this interesting aspect. So what goes in for, by way of example, I was reading through the famous pending cases, and it was really alleged that IE systems. Some IE systems sometimes spit out portions of newspaper articles, and so of course they couldn't be determined which kind of which amount of portions or shares key parts of the content, and these findings, of course, were also found through reversed technical engineering by reports, and also there is, I think, also reputational inputs aspects to be considered, because as Valentina was saying, according to how it is prompted, then going to your question on the output, the output can of course contain, as this famous lawsuit, which I will not name, recites, the spitting out of entire portions of articles, but also the spitting out of hallucinations. So what does this mean? That by reporting in such a vast way, randomically and automatically articles, then the significance and their overall meaning may vary. So then if the style is recognized, and if there is an hallucination, then there could be also in the output of the IE a matter of reputation tarnishment or disparagement. So this is another interesting aspect. As regards to to the output and in general to the protection of the IP rights? Well, as you were correctly stating, there are not so many express obligation in the European provision and regulation. Valentina has mentioned one of the few contained, which is the data mining exception, but there are a number, I believe, of implied instead obligations which can be found to mitigate at least the risk of IP infringement. Then these will be decided by national authorities and at last by the ECJ. For example, there are governance provisions and recitals which are suggesting that deployers should mitigate the risk that the outcome infringes third parties, and these are, for example, recitals 29, 65, and a number of other ones. And then, but there is not the express obligation in this sense. Then there are data governance provisions that on the data collection process without any express reference to the IP, but Article 10.2, as we were saying, refers to the appropriateness of the practices which can involve training and also the validation and testing of data. And then the bias examination is the other aspect, as opposed then to the outcoming result. And then the last, I think, implied obligation is perhaps could be inferred by the transparency provisions. So the transparency provision can include technical documentation that may also apply to IP. Even though it's not necessarily aimed at IP protection. So I deem that on the one side, IP rights in the IE Act are really meant to protect the IE system itself. And on the other side, then the issue to be addressed is really if IE systems may use the unlicensed works, and if this amounts to infringement, and then who owns the copyright or intellectual property rights on the outcome when the outcome is protectable. Because, of course, I mean, in Europe, it was noticed that even if the IE Act doesn't touch such issues on the protectability, then in the most of the cases, the IE outcome is believed not to be protectable. However, there is really a difference between, because one of the arguments was the one that you were saying. So what is the difference between using a camera for example, creating a photographic work or as an IE system to create a similar result, so the automatic result. But it really depends also on the level of contribution and on the influence on the creativity process as in general for copyright provisions. So in the end, IE output is an outcome from the probability calculations which take place within the system, and the system runs at a really high speed, which is beyond human perception, making it very difficult to detect and to control and to assess the amount of sources used for each outcome. So what I personally believe is that a relevant criteria could be applied, includes the question on whether the potential work is developed by an extent of authorships or contribution or a degree of creativity, or it's only a mechanical reproduction.
Yeah, that's an issue. I remember we discussed this in the Law Automation Days at the IE Law School some 8-9 months ago, and we discussed about the value of creation using prompting, something that is a never-ending story, and the skill and knowledge that is necessary for certain creative works, such as painting, where you need to have some skills, but you can be so creative so that using prompting, you can express your thoughts, your ideas, your creativity, and it's the machine that is performing it. I mean, it's a brush. It's still a brush that is managed by you. And there was a big debate on it. I mean, what is the line? And you know that there are some decisions from the U.S. Copyright Office, some other decisions from the Chinese courts, etc., etc. I wouldn't say that this is the never-ending story, but we will have a very big debate on it for the following months or years. And but let's move to the question of licensing, because it was in the title. Why licensing is important or could be important in this field? Do you think that licensing could be the remedy or the solution for the litigation scheme we are facing now? What's your opinion? You're muted. Yeah, yes. Right. Okay.
Yes, I'm right now. Thanks. Yes, well, this is a very challenging question. I think that in a situation when first the use of digital content and technology is global, and second, the rules in this area are still in course of definition and have not harmonized, there is a lack of legal certainty at a global level, but also at the European level, not only at a global level, but also at the European level. So question like, for instance, to what extent in the US is the use of content for training purpose covered by fair use are not answered yet. Or another question may be in Europe, what is the exact concept of use made for research purposes relevant to the exception set forth by Article 3 of the Copyright Directive? I think, for instance, to research and development activities co-financed by university and industry, there may be doubts on of whether this Article 3 applies. So again, and highly relevant, a further question may be in which machine-readable manner a reservation under Article 4.3 needs to be articulated in order to be considered appropriate. And this is an answer that does not have a unique, a question that doesn't have a unique answer at the moment, because we have at European level 27 harmonized copyright law systems. So the text and data mining exception has been implemented differently in the various member states. So all this doubtful situation, and thus in such a situation of uncertainty, if and I would be an AI developer or a user of an AI platform, I would like to avoid unpredicted costs due to litigation and potential copyright infringement. So looking from this perspective, I would say yes, licensing seems to be a solution. But to be honest, I think that voluntary licensing, at least, does have or does poses a number of challenges. And I can number a couple of challenges. First, if we consider that the amount of data is a huge amount, as mentioned, in principle, the number of licenses to be negotiated is incredibly high. And this poses very high transaction costs. And second, the second point that I will make is what if copyright holders do not sign licenses over the content? Would this block the use of the whole system? So IP right, in other words, could hinder the AI development. A third concern is that provided that copyright holders are willing to sign licenses, how can they accept conditions in the dark, so to say, so without knowing how much their content is used by the AI system? So fairness of conditions requires the sharing of information between the parties, and this is a very doubtful point. So whether the AI system will or would share the necessary information to make a fair agreement. So another concern, and then I close this point because I am taking too much time, is what I can define as AI training shopping. So what could happen is that since, for instance, in Europe, there is not a very easy legal landscape because of the opt-out system, AI developers could move to countries like, for instance, Japan, that are more AI friendly, so to say. So all these challenges may think that voluntary licensing would face several issues, and this is why the discussion should probably move, and this is maybe happening already now, to design some statutory licensing mechanisms that may be able to give at least legal certainty to AI developers, and at the same time a fair remuneration to the creative industry and to authors, not just industry but also to the creators.
Yeah.
Yes, so
that's the issue. That's the issue,
position.
Marina. What is fair, what is not fair? That's one of the issues. Marina, would you like to add something to this?
No, I think Valentina has really exploited all the issues verting in this matter.
Right. So let me add something that I pick up from other area of law. That is the question of standard essential patents and the front conditions. Maybe you know about that. So that what is standard essential patent is a question, but the other question, which are the fair and inequitable conditions for the licensing? This is a system that has been trying to be put in use, and at the end of the story, licensing, that was probably the solution for this issue, has come into a situation in which litigation is increasing. So don't you think that there could be, you have said something, Valentina, before? I mean, certain conditions that could be in a certain way mandatory could be necessary in order to get out from this litigation scenario and move to a place, to a common place where you cannot deny the possibility to grant a license, provided that there are some conditions that could be considered as fair and equitable.
Yes.
Maybe I have surprised you because I've taken this from the patent side, but
yes, no. That's. I think this is one of the big questions that at the moment there is no shared position on that. But what I can say on that is that the interplay between IP law and precisely in this case copyright law and competition law, it's very important in this case, and we already have some cases, not exactly in the field of AI, but for instance in Italy we had a case in front of the competition authority that involved CI and Meta. And there, there was a refuse to negotiate. At some point, the competition authority was involved because of a special law that we have in Italy, but this behavior was considered abuse of dominant position. So what I'm saying is that I'm not able to say now what is fair, what is not fair, but what I'm saying is that we are now moving on a terrain, so to say, that is more competition law, and copyright law maybe doesn't have to do with, shouldn't deal with this issue, but it's more yes, it's more another another. This should be decided from the competition authorities, and this is probably what we should take into consideration. That not copyright is not a regulation tool. It's not a tool for regulate competition law, in my view, and this has to be bear in mind. And we should think more of other legal instruments, and precisely in this case, competition law.
Okay, Marina.
Yes. And also, maybe if I can add, which is another prospect, maybe AI in turn, I mean, taking it from another side could be really used instead as a tool to evaluate and determine the essentiality of SEPs, because one of the major challenges, which is another perspective facing licensing in the other sector. So one of the major challenges when facing a standard essential patent is that the lack of public databases and reliable make it very difficult to determine. I don't know, the so-called fair and reasonable, not discriminatory conditions. So the example is even in the field of standard essential patents is not the question is always in the course of licensing and negotiation to which patents are essential and which are not, and this is one of the most debated questions when negotiating for example, portfolio value and royalties. And so I would imagine that if you could transport it to AI, then you could have the similar issues. But on the other side, maybe AI solutions instead could support instead the process of understanding the patent claims related to standard essential patents. And perhaps in the licensing of AI systems itself, we will ask the evaluation to the AI itself.
Yeah, well, the question here is more about, I see. This is something that is in a certain way related, well, not so related, but it's related. That is the value of the copyrighted materials and the use of it. I mean, because in certain, can you discriminate? I mean, this content has more value than this other one for purposes of training. Question number one. Question number two is, do you know, do you really know how extensive is the use of a material compared to others? I mean, is there any type of sort of black box in the use of the use that the machine makes of the copyrightable material? So it could be very difficult for a developer, for a LLM owner, to determine how to share the value with the copyright materials owner, because he really sometimes don't know to which extent the material has been used.
Yeah,
another provocation. Okay.
Hey, Valentina, you are mute.
Valentina, you're muted.
She was.
Yeah.
Yes, exactly. This is exactly on the point of, I would say, sharing of information and transparency about the use of the material, and this also has plays a role in the definition of the license conditions.
Well, that's an issue that has been raised by one of the participants in the encounter, and it relates to Italian law. Marina, it says that does the reference to AI made in the recent Italian gaming law create a justification within the prohibited or high-risk AIs under the EU Act? I'm not aware about what the Italian gaming law says, so this is your turn.
Okay, this is a very broad issue, and we will try to be synthetic. I will try to be synthetic. Okay, the EU Act, as most will know, has an approach risk base. So it has a risk. It's based on a risk approach. So there is a classification. It contains a classification of the IC systems on the basis of the risk and the degree of risk under health and other perspectives. So there are a number of prohibited artificial intelligence practices which are governed by Article 2, and this is believed to be an exhaustive list contained in Article 5 of the IE Act. So the prohibited high risk artificial intelligence systems, and these of course include, for example, systems. Let me read it from the Act, that place into the market or put into service the use of IE system for the purpose of the evaluation or classification of natural persons or groups of persons over a certain period of time based on their social behavior or inferred on predicted personal or personality characteristics. So the social scoring activities, these are prohibited, and then there is an attachment that lists further. And then there are other instead systems which are not prohibited, which are high risk systems. And among the high risk systems, for example, there are IE systems which are intended to perform preparatory tasks of assessment. And again, we have the human assessment and social scoring for, classified between the high risk. Then recently we have in Italy a new set of laws that have been recently approved, so in April 2024. And these set of laws impose to gaming operators, which are licensed operators under the Italian legal system, to, for example, conduct through the use of artificial intelligence behavioral monitoring to avoid problematic gaming behaviors. And so to classify, for example, among the players or among the market certain behavior, and to cluster them among potentially high risk of problematic gaming behaviors, vigilating in this case among such behaviors. And so this would be one of those social scoring and use of artificial intelligence which should be or prohibited or constitute artificial intelligence at high risk. However, high risk. However, on the other side, we have a specific and explicit set of national laws which are imposing as mandatory these kind of social monitoring and social scoring. So what has been believed, because the reference in the law is within the health, the player's health, so it's fundamental rights guaranteed under the Italian Constitution. And as you know, as I have mentioned, there is a licensing system. So this is also a condition to remain a licensed operators. And the law makes reference to the use of artificial intelligence to do this kind of activity, for especially for the vigilating part. So in this we have conducted some thoughts, and in fact there are causes of justification, and there is a proportionality criteria contained. And for example, when these kind of provisions are inserted in national laws, these are believed to become a justification for this kind of use. But on the other side, the high risk reasons are still there. And so what is really suggested under the recent Italian law, because we also have a new design, a law design. In Italy, we have been very proliferous in the legislative system on specifically on artificial intelligence. And what has been suggested is that there is another justification is, of course, the proof of the governance rules pertaining to this kind of use of the IC systems, and especially the human vigilance. And so to prove that there is always a human control and a human vigilance. So this kind of balances out when you have a high-risk system, which is, I think, the approach of the IE Act in this respect.
Yeah, but this is a good example. I mean, I like it very much. I mean, scoring is not bad per se. It depends on the purpose of that scoring. Could be for good or for bad. And that's a good example of a scoring for good. One of the we are coming to an end. I mean, we just have some 2-3 minutes, and there are some questions. Some of the questions you have answered already, but there's one of the participants that says that we haven't said so much, or we haven't said anything, in fact, about the terms and conditions governing the relationship between the generative AI systems and the users. And they said, do you think that the current consumer protection rules are sufficient to address the issues of ownership of the results generated by them, liability for infringements, etc., is a very good question. It could drive us to another global digital encounter. But if you have an opinion, a 30 seconds or 1 minute opinion, that could be good, right? Any of you? Once again, you're muted.
Exactly. If you can repeat it, because I had a lack of. Sorry.
She says that, do you think that the current consumer protection rules are sufficient to address the issues of ownership of the results generated by them, liability for infringements, etc.? The question is whether, because if you know that terms and conditions of several platforms includes the, let's say, right of reuse, right of appropriation of the results. So for training purposes, sometimes for other purposes, some other times. And the question is about whether or not this could fall into the consumer protection regulations, specifically in Europe, because I don't think that there's a regulation on it in the US, where the contract is low. And if you had agreed the terms and conditions of the platform, that's what rules the relationship.
Yeah, no, honestly, I don't think so. So I don't think, if I may, Marina, so I don't think that consumer law currently would be of help for users because we are talking now about IP law, a copyright law, which is I don't want to say a property right, but at least is an exclusive right. And the copyright holder can always enforce his copyright law. Then this is the position. I mean, the copyright holder can always enforce his position against the user and possibly the platform. And then yes. The consumer law could come in place in the relationship between the platform, so the AI platform in this case, the AI provider or AI system provider, and the consumer. So in this case, in this relationship, yes, maybe consumer law may protect to some extent the users.
Marina.
No, I agree. I mean, consumer laws in most countries and in Europe are based on misleadingness and unfair practices. So I think that from a general approach, I am in favor of applying general principles, as if not, you would have to adapt them to the new technology, and there will always be something new which is ahead of the law. also I do think that from a misleadingness approach and unfair uses, you could make reference to consumer laws according, depending on the behavior, and then because of these general contracts which really impose on users conditions which often are unfavorable and have not been negotiated, as we know. So there are laws in protection of users and consumers in this set, but although, as Valentina was saying, probably if there is a protected work or material that is infringed, then we have many more remedies that can be addressed more easily and in a faster way, especially concerning the burden of the proof, which are based on existing intellectual property laws and protections and remedies. I think that really what we were speaking for, what we have addressed is that first you need to determine whether in fact there is a work to protect and there is a right to be established, because too often you enforce maybe infringements, but then first you have to prove that there is a work that deserves and it's entitled to protection or an author. For example, there have been a new attempt of legislating on copyright protection in Italy, and very recently has not been approved through the whole governmental approval system, but it has added human contribution as a condition for eligibility to copyright protection. So human contribution to an extent in which a human contribution can be creative, relevant, and provable. So if you don't have the basis of the eligibility of protection in the outcome, then it would be difficult to apply infringement. And so then maybe you could really rely on consumer laws. Of course, we will need to adapt the existing consumer laws to become more specific, but they may be on unfairness of contractual imposing.
Abuse and abuse from the contractual conditions,
exactly.
Because the outputs, there are copyright laws. I mean, you can be considered the author, even in case that you have used that type of materials. I mean, that type of platforms. You know, the question of whether this is a copyrightable work or not, the contribution of the machine versus the contribution of the human being can drive to different discussions, as the consumer protection laws will drive to us. But unfortunately, we have come to an end. We cannot continue discussing, and there are some two other questions that would be answered in writing when we prepare the final report. So thank you very much to you both, to Marina and to Valentina, and Manuel de Santos, Professor de Santos, the floor is yours.
Thank you, Javier. Whoa, 1 hour has passed so quick. Yeah, this is usually what happens with the global digital encounters. But today, I think that you three, but especially Valentina and Marina, understood very well the concept of the encounter. This has been an actual conversation, and I should say also a profound discussion. When you will see the report, you will realize how many valuable reflections have come out. In a way, we have dealt with a certain number of encounters around the patent world. Now we have shifted to the copyright, and you have opened so many issues. Just I take some notes just as an example, starting with why copyright has an impact on artificial intelligence, but then the issues of copyrightability and outputs of AI systems. I remember here also how the different systems face copyright issues, both in the input and the output, licensing. Each one of these topics merits an encounter per se. Yeah, the responsibilities along the AI value chain, high-risk AI systems in the European Union, how Article 25 of the AI Act works. The interrelation, the profound interrelation between copyright, patents, and you refer clearly to the SEPs, and competition law and fair competition. Something which came also to my mind and you didn't discuss, but there's so many issues, is the issue of the copyright rules are territorial, while the AI Act is full of mandatory EU provisions. Yeah. So all in all, what I get as a conclusion is that I think it has been clearly signed today that our short, our mid-terms, I should say, that our long-term future depends in a way on the way the whole world, the complex world of AI training will be organized in the short-term future. Yeah, I would say, yeah. And I believe that this is a very difficult issue, very difficult to find a topic with so many collateral aspects and so many complexities. So this happens in most of the encounters, but certainly happened here much more clearly. Yeah. So thanks to you, to our speakers. Thank you, dear Valentina and dear Marina. Congratulations again to Javier. It's a pleasure to listen to how do you conduct again and again these encounters. I'm pretty sure, Javier, that you would have loved to have intervened more. But you know, this is the misery of the encounter. Yeah, the moderator has to moderate himself again and again and again. Again, what happens is that 1 hour passes so quick. But this is the issue, to try to bring in 1 hour as many open questions as necessary. So thanks to all of you who have been connected today, and thanks also to all of hundreds of people who will listen later on in the following weeks. You know, I think that, as I always say, that each encounter is a wall by itself, but when you take all the encounters together, this is a splendid source of knowledge. And the more encounters, the more interested persons follow when they dig into the encounters, they watch the recordings, they read the references, they read the reports, then this is an enormous amount of material and very original material. So thank you very much. Let me close then the encounter by encouraging to read the report, to continue attending the encounters. Our 35th encounter will be duly announced in the following days, and will take place before the summer break. So please take care. Come again with us in a month. To count on all of you for our encounters, and thanks for being with us again, as always. Bye-bye to all of you. Thank you.
Thank you.
Thank you.
Thank you. Bye.